अब हम अगस्त 2023 की विजन आई की मंथली मैगजीन कवर करने जा रहे हैं. सो इट इज पॉलिटी एंड गवर्नेंस, डिजिटल पर्सनल डेटा प्रोटेक्शन एक्ट, Digital Personal Data Protection Act 2003. The President of the India recently granted assent to the Digital Personal Data Protection Bill 2023. In 2000, the Supreme Court recognized the privacy as a fundamental right in case Putaswamy versus Union of a case. Following this, Justice C. Krishna Committee established by the Ministry of MITI. He proposed the initial draft of the Personal Data Protection Bill in 2018. Significance of the Digital Personal Data Protection Act: introduced the data protection law within the meaning of disruption. Data protection law को protect data protection law भी है with minimal restriction while ensuring the necessary change in the way data fiduciary process data, enable the India's digital economy and its more innovation ecosystem, enhances the ease of living and ease of doing business. The government revised the draft and introduced it as the PDP Bill 2019 bill referred to a joint committee of both the houses of parliament. However, in 2022, the government withdrew the Personal Data Protection Bill 2019 by citing the extensive changes made by the joint parliament committee to the parliament to it. MITI released a draft of the PDP Bill 2008 for public consultation, which later became PDP Act 2003. Okay, what are the principles? The principles of consented, lawful and transparent use of personal data. कि भाई consent होना चाहिए, lawful and the transparent जो the principle of purpose and limitation. Use of personal data only for the purpose specified at the time of obtaining the consent of the data principle. The principle of data minimization, collection of only as much personal data as is necessary to serve the specified purpose. The principle of data accuracy, ensuring data is correct, updated. The principle of storage limitation, storing data only till it is needed for the specified purpose. The principle of reasonable security safeguard, principle of accountability through adjudication of the data breaches and breaches of the provision of the act, adjudication on the data breaches and breaches of the provision, education on data breach and the breaches on the provision of the act, imposition of penalties for the breaches. Okay, about Digital Personal Data Protection Act 2003, it aims to regulate the processing of the digital personal data while ensuring the individual's right to protect their data and the need to process it for lawful purpose. It protects the digital personal data, that is the data by which a person may be identified, by providing the obligation of the data fiduciary, that is the person, company or the government entities who process data for data processing, that is the collection and storage or any process operation on personal data. The rights and the duties of the data principal, that is the person to whom the data relates. Rights and duties. The financial penalties for the breach of the right, duties and the obligation. Now what are the key portion of the act? Specification. Applicability. Details of the digital personal data within India where such data is collected in digital form or in non-digital form and digitized subsequently. Processing of digital form and non-digital form then digitized subsequently. Processing of the personal data outside India. It is for offering goods and services in India, does not apply to personal data processed for any personal purpose. Personal data processed for any personal purpose. Personal data that is made or caused to be made publicly available by the data principal to whom such personal data relates, or any other person who is under the legal obligation to make such personal data publicly available. Consent. Personal data may be processed only for lawful purpose after obtaining the consent of the data principal, who shall have the right to withdraw consent at any time. Personal data may be processed only for the lawful purpose after obtaining the consent of the data principal, who shall have the right to withdraw consent at any time. The personal data may be processed only for the lawful purpose after obtaining the consent of the data principal, who shall have the right to withdraw the consent at any time. Consent will not be required for any legitimate uses, including the provision of benefit or services by the government, medical emergency for a child or a person with a disability. Consent will be provided by the parent or the legal guardian. Data Protection Board of India proposed for the establishment of Data Protection Board of the central government. Key function of the board: monitor the compliance as well as impose the penalty, directing the data field to take necessary measures in event of data breach. Hearing grievances made by the affected person. Board members will be appointed for 2 years and will be for re-appointment. Appeal against justice will lie with the telecom dispute settlement and appellate tribunal. Rights and the duties of the data principal. Data principal will have the right to obtain information about processing. Data principal will have the right to obtain information about processing, seek correction, erasure of personal data, grievance redressal, right to nominate a person to exercise right in case of death or incapacity. Data principal must not register a false or the frivolous complaint and furnish any false particular. Violation of the duties will be punishable with a penalty of ₹10,000. Obligation of data fiduciary. Data fiduciary entity determines the purpose and the means of processing, must ensure the accuracy and the completeness of data, build reasonable security safeguard to prevent a data breach, inform DPI, Data Protection Board of India. Obligation of data fiduciary entity will determine the purpose and the means of the processing, must ensure the accuracy कि डेटा जो है वो एक्यूरेट है, कंप्लीट है, build reasonable security safeguard to prevent data breach, inform DPI and affected person in the event of a breach, erase personal data as soon as the purpose has been met and retention is not necessary for legal purpose. Central government may notify any data fiduciary as state data fiduciary. Significant data fiduciary based on the factors such as volume and the sensitivity of the personal data processed is to the right to the data principle, potential impact on the sovereignty, integrity of India, security of the state, risk to the electoral democracy, public order. So significant data fiduciary will have certain additional obligations, including the appointing a data protection officer and an independent data protection officer, independent data auditor, and undertake impact assessment. Independent data auditor. Right to the data principle and obligation on data fitness except data security will not apply in specified case, including for notified agencies in the interest of the security, sovereignty, public order, for research, achieving or statistical purpose, for status or other notified categories of data fiduciary. Right to the data principle and obligation of data fiduciary will not apply in specified case, including for notified agencies in the interest of security, sovereignty, and public order, for research, achieving or statistical purpose, for startup or other notified categories of data fiduciary, to ensure legal rights and the claim, prevention and investigation of offences, to perform judicial or regulatory function, to process in India personal data of non-resident under the foreign contract. The central government may exempt certain categories in the interest of the security of the public order. Okay, while processing the personal data of a child, data fiduciary must not undertake processing that is likely to cause any detrimental effect on the well-being of the child, tracking behavior monitoring or targeted advertising. Behavior monitor करना, targeting advertising. Bill allows the transfer of the personal data outside India except to countries restricted by the government. Act specifies penalties for various offences such as up to ₹200 for the non-fulfillment of obligation for children and 250 crore for failure to take security 250 or 200 for obligation children. Okay, limitation होता है. It violates the fundamental exemption for the state को कुछ exemption मिला है, तो it may lead to data collection, then processing and retention beyond what is necessary, and may violate the fundamental right to process using exemption. A government agency may collect data about a citizen to create a 360-degree profile for surveillance. The transfer of the personal data outside India may not ensure adequate data protection is done in the countries where the transfer of the personal data is allowed. The Act has removed the Section 43A of the IT Act, which mandated companies to compensate user in case of mishandling their data. 43 IT Act 2000. Aggrieved individuals are required to first approach the data fiduciary redress mechanism. Approach the data fiduciary redressal mechanism. Unresolved grievances can be escalated to a data protection board, which further appeal to the Telecom Dispute Settlement and Tribunal. Right, the Act proposes that the personal information on the public official will not be disclosed under the right to RTI Act, which personal information of public official will not be disclosed under the RTI Act, which could aid corrupt practices by not disclosing asset and liability. The Act provides that a data fiduciary will not undergo any processing that has a detrimental effect on the well-being of a child. However, there is no definition of the detrimental effect or any guidance for determining such effects. There is no provision for some right. The Act does not grant the right to data portability and the right to be forgotten to. The Act does not grant the right to data portability or the right to be forgotten to the data principle. Right to data portability. It allows the individual to obtain as well as reuse their personal data for their own purposes or different service. It is the right to remove or erase the content so that it is not accessible to the public at large. Cross-border data governance mechanism need to be developed for governing the cross-border transfer of the data, especially for countries not mentioned in the list provided by the notification. The right to data portability and the right to be forgotten should be provided, especially in case of data collection and storage poses harm to the reputation, his life, identity of a person. Terms like sovereignty, integrity of India should be clearly defined, along with a defined procedure to provide exemption. Specific time should be defined to delete the data once the purpose has been fulfilled for the data or principal withdraws his or consent to the processing of the personal data. Cross-border data governance, data right, prevent misuse and quantifying time duration. General data protection regulation, digital personal data protection regulation. General data protection regulation applies to processing of personal data wholly or partly by the automated means. Applies to processing of personal data wholly or partly by automated means and to personal data which forms or will form a part of the filing system. Minor under 16 age need parental consent. Member states of Europe can lower this age to 13 or the region. BCS should be notified to the supervisory authority within 72 and possibly to the affected data subject. GDPR, General Data Protection Regulation, does not include the right to nominate, however, however, provides for the right to portability. Nominate. Organizations have 30 days to respond to a data subject request. General Data Protection Regulation lays down specific mechanism for transmitting data to the third country, such as standard contractual clauses and binding corporate rules. Both controllers and the processors are under the obligation to appoint a DPO, Data Protection Officer, Data Controller, and Data जो डेटा को कंट्रोल करता है, डेटा प्रोसेसर आर रिक्वायर्ड टू मेंटेन द रिकॉर्ड्स ऑफ प्रोसेसिंग एक्टिविटीज़. एक मिनट, सॉरी. दिस पर्सनल डेटा प्रोटेक्शन विल अप्लाई टू डिजिटाइज पर्सनल डेटा, ठीक है, एंड नॉन डिजिटाइज्ड पर्सनल डेटा विच इज सब्सिक्वेंटली डिजिटाइज. Children at the age of 18 need consent from the parent and guardian. The act does not specify time frame for personal data breach notification, 72 hours. Also, the act comprises an additional right to nominate. ये does not include the right to nominate, include the right to nominate while omits the right to portability. ये और यहाँ पे it provides right to portability while does not which omits the right to portability in timeline to respond to the data principal request has not been specified. Specific means potential data does not have any transfer mechanism for transferring personal data. Only the significant data fiduciary shall have to appoint DPO as a point of contact. तो सारे कंट्रोलर्स और प्रोसेसर जो भी कंट्रोल करे प्रोसेसर उनको डीपीओ करना पड़ेगा, सिर्फ सिग्निफिकेंट डेटा फिड्यूसीज करना पड़ेगा. Data Protection Board. The Act does not include any obligation for data fiduciaries to maintain the record of processing activities. यहाँ पे maintain करना पड़ेगा. The following India's criminal laws. The government introduced 3 bills in Lok Sabha to replace the existing criminal laws in India. भारतीय न्याय संहिता IPC 1860, IPC 1860, भारतीय न्याय संहिता कोड ऑफ क्रिमिनल प्रोसीजर 1973, भारतीय नागरिक सुरक्षा संहिता कोड ऑफ क्रिमिनल प्रोसीजर, भारतीय नागरिक सुरक्षा संहिता, Indian Evidence Act 1872, भारतीय साक्ष्य बिल. Three bills have been referred to as standing committee. Need of these bill. Addressing the large pendency in those union law minister stated almost 4.7 crore cases are pending collectively in the Supreme Court, High Court and Supreme Court. Addressing large pendency in court. Addressing large pendency in court. Union law minister stated almost 4.7 crore cases are pending collectively. Okay. 4.7 crore cases pending to address large pendency time is complex legal procedure बहुत ही complex है, resources नहीं है. They have led to many under trial languishing in the jail, constituting 70% for the prison population, increasing conviction rate. The criminal justice system inefficient है, including inadequate forensic investigation, polishing deficiencies, and the influence of the powerful individual on the law enforcement. They contribute to the low conviction rate, around 50%. Evolution of the criminal justice system. Society में change, emerging challenges require an evolving as well as adaptable criminal justice. कि बहुत सारे सोसाइटी में चेंज आ रहे हैं, बहुत सारे इमर्जिंग चैलेंज हैं, तो इट ऑल रिक्वायर्स इवॉल्विंग एंड अडेप्टेबल क्रिमिनल जस्टिस सिस्टम. Also, integrating modern technology in evidence gathering, storage, presentation would aid in discovering various criminal dimensions. Erasing colonial legacy. India's criminal justice system is rooted in its colonial past, which has led to a set of laws and procedures that may not be entirely relevant or suitable for the country's current socio. Erasing colonial legacy. India's criminal justice system is rooted in colonial past, which has led to a set of laws and procedures that may not be entirely relevant or suitable for the country's current socio-economic and cultural context. भारतीय न्याय संहिता 2023. भारतीय न्याय संहिता 2003 will repeal the IPC 1860, which is the principal law on the criminal offence. In 1834, Indian Law Commission was constituted under the chairmanship of Lord Thomas Babington Macaulay to examine the jurisdiction, power and rules of the existing court. King का jurisdiction क्या रहेगा, power रहेगा और rules of the existing court, as well as the police establishment and the laws in force in India. It introduced a draft of the IPC in 1837, which was based on the English common law with colonial interest in mind. The establishment enactment of IPC was deleted to subsequent division after the 1857 and it was enacted in 1860 and came into force in 1862. The Charter Act of 1833 established an all India legislature. All India Legislative Council created an office of law members and provided for the appointment of a law commission. After independence, it underwent a severe amendment and all these alteration and modification made it a complicated code of law. The new bill aims to strengthen the law and order. Law order को strengthen करेगा, simplifying legal procedure, making existing laws relevant to the contemporary situation of the common man. Major provision of the bill: sedition. The bill removed the offence of sedition, that is section 124A of the IPC. It instead penalizes the following: exciting or attempting to excite secession, exciting or attempting to excite क्या secession, armed rebellion or subversive activities, some subversive activities, encourage feeling of separatist activities, subversive, secession, armed rebellion, subversive activities, separatist activities, endangering the sovereignty, unity or integrity of India. These offences may involve the exchange of word or signs, electronic communication, or the use of the financial means. This will be punishable with imprisonment up to 7 years or life imprisonment and a fine. The bill defines terrorism as an act that intends to threaten the unity, integrity and security of the country, to intimidate the general public or disrupt the public order. Terrorist acts include Terrorism as an offense. The bill defines terrorism as an act that intends to threaten unity, integrity, security, to intimidate the general public or disturb the public order. Terrorism act includes using firearm, bomb, hazardous substance, biological chemical to cause a death, danger to life, or spread a message of fear, destroying property, or disrupting essential services. Essential services activities include in the treatise listed in the second schedule of the Unlawful Activities Prevention Act 1965, such as the unlawful seizure of the aircraft or taking off hostages. So the bill defines organized crime as a continuing unlawful activity. Organized crime, unlawful activity such as kidnapping, extortion, contract killing, financial scams, cyber crime, etc., carried out by individuals using singly or jointly as a measure of or on behalf of a crime syndicate. The terrorism offense, organized crime as an offense. Potential impact, subjective interpretation, unclear definition of criminal activity may lead to their अगर कोई भी क्रिमिनल एक्टिविटी की अच्छी सी डेफिनेशन नहीं है तो वो improper application affect the freedom of speech and expression. For example, subversive activities might include any form of critique. Take a terrorist act which now include damage to property and provocation, which now include damage to property or provocation or intimidation. Enhanced policing power, enhanced discretionary action taking powers of the police personnel may increase the scope for arbitrary police action. Delays in existing trial, though these will exclude their application to pending proceedings and trial, courts are likely to be bombarded with interpretation resulting in delays in the actual trial of the victim. Interpretation, enhancing police power, arbitrary police action, subjective interpretation. Subversive activities क्या होता है, टेररिस्ट एक्ट क्या होता है जिसमें डैमेज टू प्रॉपर्टी और प्रोवोकेशन इंटीमेशन में आ गया. भारतीय नागरिक सुरक्षा संहिता ने रिवील्ड द कोड ऑफ क्रिमिनल प्रोसीजर 1973. द कोड प्रोवाइड्स फॉर द प्रोसीजर फॉर अरेस्ट, prosecution and bail for offences under various acts including the IPC reason. CRPC was first enacted in 1882 but the British Parliament undergone several amendments, most importantly in 1898, 1923 and 1925. So Law Commission of India अपनी 841st report पर declared a significant division of the code which led to the creation of CRPC 1973 41st report. Major provision क्या, detention of under trial. First time the offenders will be released on bail if they have completed detention for 1/3 of the maximum imprisonment on an offence. If the accused has spent half of the maximum period of imprisonment during investigation or trial, she must be released on a personal bond. ठीक है, अगर उन्होंने if he had spent half of the maximum period of imprisonment, if the accused has spent half of the maximum period of imprisonment during investigation or trial, she must be released on a personal bond. This does not apply to offences which are punishable by death and life imprisonment. Detention of under trial. First time offenders will be released on bail if they have completed detention for 1/3 of the maximum imprisonment on an offence. If the accused has spent half of the maximum period of imprisonment during investigation trial, she must be released on a personal bond. This does not apply to offences which are punishable by death and life imprisonment. Trial in electronic mode. All trial inquiries and proceedings will be held in electronic mode. Any police officer can request for medical examination of the accused. In certain cases such as rape, medical examination of the accused. Okay, for an accused, जो accused है such as rape, medical examination of the accused in certain it maintains forensic investigation for offences of punishment at least 7 years of investigation. If a state does not have a forensic facility, it decides to utilize its facility in another state. Signature and finger impression. It allows for the collection of the specimen signature, handwriting, sign, handwriting, finger impressions and voice samples from each person whether arrested or not. It prescribes the timeline for various procedures such as giving judgment, informing victims of the progress of the investigation and framing of charges. It provides for the conduct of trial and pronouncement of judgment in the absence of the proclaimed offender. Proclaimed offender refers to a person who is accused of an offence punishment with imprisonment of at least 10 years or death and fails to appear at a specified time and place as specified by the court. The bill adds that death sentences can only be converted to life imprisonment and life, stopping political waiver of punishment. The bill adds that death can only be converted to life imprisonment and life imprisonment can be pardoned only within 7 years of punishment. Expedited case disposal. Prescribed timeline for different judicial procedures and framing of charge sheet. Timeline बता दिया उन्होंने बहुत सारे judicial procedure or charge sheet will help in the timely delivery of justice, integration of technology, preferred forensic investigation of crime, integration of the ICT tools into investigation and judicial process, improvement in right of victim, provision allows the registration of a file in any police station irrespective of whether the offence was committed, fairness in investigation, mandatory video recording of search and seizure seeks to address the fairness in the police investigation. The period during which an arrested person can be sent to police custody has been extended. Increase in detention period. The period during which an arrested person can be sent to police custody has been expanded. भारतीय साक्ष्य बिल 2003. भारतीय साक्ष्य बिल 2003 will repeal the Indian Evidence Act of 1880. The Act provides rule for the admissibility of evidence and in legal provides for the admissibility of evidence. The Evidence Act was enacted in 1872 with a view to consolidate the laws relating to the evidence on which the court could come to a conclusion and pronounce the judgment. Okay, come to a conclusion, pronounce the judgment. The Evidence Act was enacted in 1872 with a view to consolidate the laws relating to evidence on which the court could come to a conclusion, pronounce the judgment. The law of the evidence not being substantive or procedural law falls in the category of adjective law. Law of evidence, adjective law, will define the pleading and the methodology by which the substantive or the procedural laws are operationalized. The existing law does not address the technological advancement undergone in the country during the last few decades. Substantive law, these are basically laws derived from common statutory constitution and the principles found in the judicial decision. Penal law, law of property, procedural law, it is that law which prescribes a method of enforcing the right or obtaining the redress for the invasion machinery for carrying on a suit. Example, code of civil procedure, code of criminal procedure. Substantive law, these are basically laws derived from common statutory constitution and principles found in the judicial decision. Penal law, law of property, it is that law which prescribes a method of enforcing rights or obtaining redress for the enforcing their right, obtaining redress for the invasion machinery for carrying on a suit. Code of civil procedure, code of criminal procedure. Where these exclusion law does not address the technological advancement undergone in the country during the last few decades. The law of evidence is falling in the category of adjective law, which define the pleading and the methodology by which the substantive or the procedural laws are operationalized. Substantive law and a procedural law. Law of property, penal law. Okay. Major provision of the bill: electronic or digital record as evidence. It provides that the electronic record, digital record will have the same legal effect as paper record. Expand the electronic record to include information stored in the semiconductor memory or any communication device, smartphone, laptop. This will also include record on the email server, log, smartphone, locational evidences, and voicemail. Oral evidences include statement made before court by witnesses in relation to the fact under inquiry. The bill adds any information given electronically to be considered as oral evidence. It refers to the trial of more than one person for the same offense in a joint trial. If a confession made by one of the accused which also affects other accused is proven, it will be treated as a confession against both. In a joint trial, if a confession made by one of the accused which also affects other accused is proven. Potential expansion in the use of the electronic evidence. This can lead to the potential impact. This can lead to the reduction in wrongful conviction and provide help in investigation cases faster. It emerges from the seizure of the electronic device and access to the sensitive information that may be stored within them. The issue of privacy, expansion in the use of the electronic evidence. The potential of the reform of the criminal justice system hinges on the alignment with its capacity to implement it effectively. तो देखो, आपने इतना रिफॉर्म कर दिया लेकिन वो इफेक्टिवली नहीं होगी तो फिर प्रॉब्लम है. द सक्सेस ऑफ क्रिमिनल लॉ रिफॉर्म्स हैज़ टू टेक एन आर्डुअस जर्नी फ्रॉम इट्स इंसेप्शन, then formulation, then implementation approach and regular oversight. CEC and other EC appointment, condition or service and term. Recently, the Union government introduced the Chief Election Commissioner and other election commissioner appointment, their condition of service and their term of bill 2023 in Rajya Sabha. It repealed the election commissioner condition in 1991 wala. The bill aims to regulate the appointment, his condition of service and terms of office of the Chief Election Commissioner and other election commissioner. It also seeks to set up a procedure for the transaction of the business by the Election Commission and for matters they are connected therewith or incidental thereto. The present process of appointment of CEC and EC as per Article 324 for the Election Commission consists of CEC and such a number of other ECs that the President may decide. Supreme Court in Anu Baranwal vs. Union of India judgment declared that President shall make the appointment of the CEC and EC on the advice of constituency consisting of Prime Minister, Leader of Opposition on the Lok Sabha. In case no LOP is applicable, the Leader of the largest opposition party in the Lok Sabha in terms of the numerical strength and the Chief Justice of India. Prime Minister, Leader of Opposition and Chief Justice of India. Till the Supreme Court ruling, Election Commissioner, the Chief Election Commissioner has been appointed by the President after the recommendation for the government. Specification details: Chief Election Commissioner and other election commissioner will be appointed by the President on the recommendation of the Selection Committee, Prime Minister, Leader of Opposition and Chief Justice of India. It will consist of Prime Minister as Chairperson, Leader of Opposition and as member, Union Cabinet Minister, Leader of Opposition in Lok Sabha as its member. A Union Cabinet Minister is nominated by the Prime Minister as a member. If the Leader of Opposition in Lok Sabha has not been recognized, the Leader of the single largest opposition party in Lok Sabha will assume the role. Such committee, headed by the Cabinet Key Secretary, headed by the Cabinet Secretary and comprising 2 other members, not below the rank of the Secretary of the Government of India, having the knowledge and experience in matters relating to election. It will prepare a panel of 5 persons for the consideration of the Selection Committee for the appointment of. Prepare a panel of 5 persons for the consideration of the Selection Committee for appointment of CEC. The Selection Committee may also consider any other person. Selection Committee, any other person than those included in the panel by the Selection Committee. Qualification of the person who are holding or have at least a post equivalent to the rank of Secretary. Cabinet Secretary not below the rank of Secretary. For equivalent the rank of Secretary, the Government of India, such a person must have a knowledge and experience in the management and knowledge and experience in management and conduct of election. CEC and other ECs are hold office for a term of 6 years from the date on which he assumes his office or till he attains the age of 65 years. CEC and ECs shall hold office for a term of 6 years from the date on which he assumes his office till he attains the age of 65 years, whichever is earlier. CEC and other ECs shall not be eligible for reappointment where an EC is appointed as CEC. His term of office shall not more than 6 years in aggregate, as the EC and CEC salary allowance and service condition of the CEC and other ECs will be the same as that of Cabinet Secretary under Article 324 of the Constitution. CEC cannot be removed from his office in a manner similar to that of a Supreme Court judge. This is done through an order of precedent based on a motion passed by both the houses of Parliament. Same motion for removal must be adopted with majority support of the total motion. Majority support of the total membership, at least 2/3 members present and voting. EC can only be removed from office on the recommendation of the CEC. Okay, all business of the election commission is to be conducted unanimously. Conduct of business unanimously. In case of difference of opinion between the CEC and the EC on the matter, it shall be decided through majority. Now, what are the concerns associated with the bill? Again, the Supreme Court. The proposed legislation seeks to drop the Chief Justice of India from the selection process and override the Supreme Court judgment in the Anubar Banwal versus ड्रॉप द चीफ जस्टिस ऑफ इंडिया. इन्होंने क्या किया, सिलेक्शन प्रोसेस से अच्छा अभी तक जो चीफ जस्टिस थे, लेकिन अब इन्होंने क्या किया, चीफ जस्टिस को हटा दिया और जो सिलेक्शन कमेटी में कैबिनेट यूनियन कैबिनेट मिनिस्टर इज नॉमिनेटेड बाय द प्राइम मिनिस्टर एज ए मेंबर. ओके सुप्रीम कोर्ट का जजमेंट जो आया था अनूप बनवाल केसेस में, उसको भी अंडरलाइन कर दिया है. न्यूट्रलिटी द कंपोजिशन ऑफ द सिलेक्शन कमेटी में लीड टू द डोमिनेंस ऑफ द रूलिंग पार्टी. Okay, they will authorize the selection committee to go beyond their such committee recommendation and appoint anyone it wants as CEC. Go beyond the such committee's recommendation, appoint anyone it wants as CEC, thus making the entire such process redundant. Independence of CEC bringing the Election Commission of India under the control of the political executive is repugnant to the concept of independent and impartial election commission. Removal of EC. Article 324(5) of the Constitution should be amended to aid to the removal procedure of the two election commissioners with that of the chief election commissioner. Thus, the equal constitutional protection should be given to all the members of the ASI in matters of removability from office. Multi-stakeholder approach. Steps should be taken to engage the prominent jurists, CGI, independent experts, civil society members to widen the committee's scope and ensure transparency in the appointment process. The elevation of an election commission should be based on seniority. Unless the three-member committee should be based on seniority, unless the three-member committee, for reason to be recorded in writing, finds such commissioner unfit as recommended by the law commission. Three-member committee. More comprehensive consultation. Before finalizing the bill, the government should conduct comprehensive consultation with opposition parties, legal experts and stakeholders. Aspect of the election process and the reform. Recently, the department and related parliamentary standing committee on personal public grievances, law and justice tables a report on a specific aspect of the election process and their reform. The report analyzes the significance of the elections in India and the influence on जो भी election होता है उसका influence कहाँ पर होता है, democratic governance में, political representation में, सुधार. Democratic governance, political representation, societal. Democratic governance, political representation, societal purpose. It explores the different phases, including voter participation, comprehensive representation through a single electoral roll, transparency, accountability of a candidature, and minimum age for contesting election. It explores potential phases, including voter participation, comprehensive representation, single electoral roll, transparency, accountability, minimum age for contesting election. Common electoral roll. By consolidating the electoral roll into a single comprehensive database, the government could eliminate duplication and streamline the process. Provision. India has two types of electoral roll. General electoral roll overseen by the ECI. Separate electoral rolls prepared by SEC. State Election Commission. Election Commission of India under Article 324. Election Commission of India administers union and the state election like Lok Sabha, Rajya Sabha, state assembly in India. Okay, India has two type of electoral roll. General electoral roll जो कि ECI, separate roll separated by state election commissioner. Election Commissioner of India, ECI in Article 324. ECI administers the union and the state election in the Lok Sabha, Rajya Sabha, state assembly in India. State election commissioner under Article 243K. The state election commissioner in each state has been constructed to conduct a fair election to the local bodies, panchayat and municipality. 243K. Issues in the preparation of the CER, Chief Electoral Roll. Absence of a permanent electoral roll. Before every election, a fresh electoral roll for the local body is prepared. Unlike the assembly, local bodies local bodies do not maintain a permanent electoral roll. This leads to duplication of effort. Delimitation frequency for assembly. For assembly, parliamentary constituency delimitation happens less frequently, usually up to 15 से 20 years. On the other hand, delimitation local bodies is often done before election. So periodic delimitation ensures the fair. ये क्यों? So periodic delimitation जो होना चाहिए, it ensures fair political representation in the broader landscape. Constitutional challenge: implementing a CER as proposed by the central government and ECI is presently outside the scope. Chief electoral roll जो है is presently proposed by the central government and ECI is presently the outside the scope of article 325 amended the use of separate electoral roll. यहाँ पे हम लोग क्या यूज़ कर रहे हैं? CER. CER क्या है? एक सेकेंड. कॉमन इलेक्टोरल रोल. अभी हम क्या करते हैं? सेपरेट इलेक्टोरल रोल यूज़ करते हैं. ओके. विच मैंडेट 325 में कहा है कि हम सेपरेट इलेक्टोरल रोल फॉर इलेक्शन टू पार्लियामेंट एंड स्टेट लेजिस्लेचर्स है. स्टेट सेपरेट इलेक्टोरल रोल फॉर पार्लियामेंट एंड स्टेट लेजिस्लेचर्स. लेकिन ये कॉमन इलेक्टोरल रोल की बात कर रहे हैं. फेयर एंश्योर डिलिमिटेशन फ्रिक्वेंसी कम हो जाएगी. पीरियोडिक डिलिमिटेशन एंश्योर द फेयर पॉलिटिकल रिप्रेजेंटेशन. और absence of permanent electoral roll, duplication of word. Recommendation: ECI may develop a comprehensive plan that considers all the factors involved in implementing a common electoral roll before making any changes to the current regulation. ECI should consider that constitutional provision before preparing the CAR and adhere to the principle of federalism. ECI may develop a comprehensive plan that considers all the factors involved in implementing a common electoral roll before making any changes to the current regulation. ECI should consider the constitutional provision before preparing the CER. The ECI, Election Commission of India, may develop a comprehensive plan that considers all the factors involved in implementing a common electoral roll before making any changes to the current legislation. ECI should consider the constitutional provision before preparing the common electoral roll and adhere to the principle of federalism. ECI and legislative departments should collaborate to examine the effects of the delimitation process, especially in the challenging terrain. ECI and legislative department collaborate to encourage the state to utilize the Election Commission's electoral roll when creating their own until there is a change in constitutional provision or statutory provision. ECI should establish a legal provision or an alternative mechanism to ensure that non-citizens with Aadhaar are not included in the common electoral roll. False declaration during the filing of nomination for election. To ensure the integrity of the democratic process, it is crucial for the government to take strict measures to deter the filing of false declaration or affidavit. Candidate in election must submit an affidavit form 26 as per the conduct of election. Candidates in election. Candidate in election, they must submit an affidavit. Affidavit मतलब form 26 per the form 26 affidavit per the conduct of election or election rules 1961 disclosing asset liabilities and education. False information is a legal violation punishable under the section 125A of the Representation of People Act. False information, false affidavit can be detrimental to the fairness of the election process as they can mislead the voters and affect their choices. Mislead voters, affect choices. False affidavit mislead voters, affect their choices. Government should set up a verification process for affidavits and promptly inform the election commission of any false data to ensure the adherence to regulation. Representation of People Act 1951 and needs to have a clear definition of what constitutes a false declaration or affidavit. Punishment under the section 125A of the Representation of People Act 1951 should be increased for filing a false affidavit from 6 months to up to 2 years and a fine depending on the severity of the offence. However, this penalty should only be applied in exceptional case and not for minor errors. Okay. Expediting the resolution of the disqualification cases. Expediting resolution of disqualification as prolonged litigation undermine the intended purpose of legal provision. Expediting the resolution of disqualification cases. Prolonged and litigation undermine the intended purpose of legal provision. Establishing parity between the minimum age of voting and contesting election. Youthful representation in legislative bodies is crucial as they advocate for peer, address youth-centric concern and transform the public political discourse, influencing both the internal and external government discussion. Presently, the age for contesting election for Lok Sabha, Article 84 and legislative establishing parity between minimum age of voting and contesting. Youthful representation in legislative bodies is crucial as they advocate for peers, address youth-centric concerns and transform the political discourse, influencing both internal government and external government discussion. Presently, the age for contesting election for Lok Sabha Article 84 and Legislative Assembly Article 173 is 25 year. Rajya Sabha Article 84 and Legislative Council 173 is 30 year. Only 2.2% of the Lok Sabha MPs are under the age of 30. Lack of the parity between the minimum age of voting 80 year and contesting election 25 year has led to low participation by India's youth population in the political arena. As per the ECI, it is unrealistic to expect 18-year-old to possess the necessary experience and maturity for this responsibility. such as reducing the minimum age requirement such as reducing the minimum age requirement for candidacy in assembly election. Reducing the minimum age requirement for candidacy in election would give young individuals equal opportunity to engage in democracy. Prioritize providing comprehensive civic education program to equip civic education. जो भी यंग पीपल उनको सिविक एजुकेशन दो विद द नॉलेज एंड द स्किल नेसेसरी फॉर पॉलिटिकल एंगेजमेंट. गवर्नमेंट, पॉलिटिकल पार्टी, यूथ ऑर्गेनाइजेशन, दे शुड वर्क टुगेदर टुवर्ड्स इनेबलिंग ग्रेटर यूथ पार्टिसिपेशन इन डिसीजन मेकिंग प्रोसेस. जितने भी गवर्नमेंट हैं, पॉलिटिकल पार्टीज़ हैं, गवर्नमेंट, political parties and youth organization, they should work together naming the greater youth participation in decision making process. Government of the NCT of Delhi Act 2023. Parliament passed the Government of NCT Delhi Amendment Act 2023. Government of NCT Delhi Act repealed the NCT of Delhi Amendment Ordinance 2023. The ordinance giving the Delhi Government of NCT 2023. Okay, the ordinance giving the Delhi Lieutenant Governor more powers over the Delhi government was issued after a decision of the Supreme Court in the GNCTD versus Union of India case. The question before the court was whether the Delhi government headed by the elected chief minister or the LG appointed by the president would have control over the service and civil. Okay. The ordinance giving the Delhi Lieutenant Governor more powers over the Delhi government was issued after a decision of the Supreme Court in Government of NCT Delhi versus Union case 2023 case. The question before the court was whether the Delhi government headed by the elected chief minister or the LG appointed by the president would have a control over the service and civil servants in India. The Supreme Court granted that the government of Delhi had complete command over the most services in capital, leaving out public order, land and police over the central government exclusive power. In those that the Supreme Court ruled that the LG did not have independent decision making process and he was bound to follow the aid and advice of the Supreme Court advice of the Council of Ministers. Governance model of Delhi NCT. Classification as duty under the State Reorganization Act 1956. Delhi was classified as a duty and under Article 239 of the Constitution. It states that duties are directly governed by the President or an administrator appointed by the President. Following the recommendation of the S. Balakrishna Committee, 69 Constitutional Amendment Act of 1991 conferred special status on Delhi and designated as the NCT of Delhi National Capital Territory. It added Article 239A to the Constitution and made Delhi a UT with the legislature and the Council of Ministers. LLG is designed as the administrator of the Delhi, operating with the aid and advice of the Council of Ministers. Delhi power of Delhi legislature. The Delhi Legislative Assembly has the power to legislate over subject in the state lead concrete except for police, public order and land. The Delhi government has executive power over the same subject same subjects. The Delhi government has executive power over the same subject. Also, Parliament can legislate over all matters in the state and the concurrent list related to Delhi. Parliament can legislate over all matters in the state and the concurrent list related to Delhi. GNCT, Government of National Capital Territory. The Government of National Capital Territory Bill of Government of National Capital Territory of Delhi Act 1991 laid out the framework for the functioning of the Delhi Assembly and the Delhi government. It outlined the power of the Assembly, the discretionary powers of the LG and the Chief Minister's duty to provide information on the LG. Challenges in the governance of Delhi. Unclear status. Article 1 read with Article 239 provide that the duties are to be governed solely by the President. However, Delhi's special status creates ambiguity in the administrative process. Delhi's special status creates Article 1 read with Article 239 provide that the duties are to be governed solely by the President. However, Delhi specifically create ambiguity in the administrative process. The President, Parliament, Supreme Court, various constitutional functionaries, foreign diplomatic missions, and international are located in Delhi. To this requires maintaining the highest possible national standard in the administration and governance of the NCT of Delhi. Any decision taken in respect to Delhi also affect the entire country, having the potential of putting the national reputation, image, credibility, and prestige at stake. Reputation, image, credibility, and prestige at stake due to the disagreement between LG and the elected government. There are delays in decision making, creating inefficiency and uncertainty in governance. National Capital Civil Service Authority. National Capital Civil Service Authority. The Act establishes the National Capital Civil Service Authority to make recommendations to the LG ordering certain National Capital Civil Service Authority. The central government will appoint both the Principal Home Secretary and the Chief Secretary. All decisions of the authority, Home Secretary, Chief Secretary and Authority will be based on a majority vote by the members representing voting. The matters where the LG may act solely in its discretion are matters outside the legislative competency of the Delhi Legislative Assembly but which have been delegated to the LG. Matter which she is required by law to act in its discretion or exercise any judicial or quasi-judicial function powers will be. The Act expands the discretionary role of the LG by giving him power to approve the recommendation of the National Capital Civil Service Authority or return them for reconsideration. In the case of a difference of opinion between the LG and the NCC, the formal decision will be the former decision will be final. Disposal of matters by minister. Certain matters must be submitted to the LG by the Minister of the Delhi government through the Chief Minister and Chief Secretary for his or opinion prior to the issue of any order. These include proposal affecting the peace, tranquility of Delhi, relation between the Delhi government and the central government, Delhi government and the central government, Supreme Court or the state government, summon, prorogue and dissolution of the Legislative Assembly, matters on which LG is to give an order in his sole discretion. Matter on which LG is to give an order in his sole discretion. Okay, summon, prorogue and dissolution of Legislative Assembly. National Capital Civil Service Authority, Chief Minister of Delhi as a chairperson, Personal Home Secretary of Delhi Government, Principal Home Secretary of Delhi Government as Member Secretary, Chief Secretary of the Delhi Government. Duties of the Secretaries. Chief Minister of Delhi, chairperson कौन है? Chief Minister of Delhi, Principal Home Secretary of the Delhi Government as Member Secretary, Chief Secretary of the Delhi Government as Member, Chief Secretary of the Delhi Government as Member. The concerned department secretary must bring certain matters that may bring the Delhi government into controversy to the notice of the LG Chief Minister and Chiefs. The concerned department secretary must bring certain matters that may bring the Delhi government into controversy to the notice of LG Chief Minister and Chief Secretary. Key issues with the Act. Power to central government. The Act gives the central government control over the transfer posting of officers in Delhi. There is a departure from the Supreme Court judgment in the government of NCT of Delhi with the Union of India 2003. The meeting of NCCA must be convened without the presence of the Chief Minister as the quorum is of 2 members. Can be convened without the presence of the Chief Minister as the quorum is of 2 members. Triple chain of accountability. Conferring powers over the transfer and posting of officer to NCCA may break the triple chain of accountability. Conferring powers over the transfer and posting of officers to the NCCA may break the triple chain accountability. According to the Supreme Court, democratic government rests on the triple chain accountability. Triple chain accountability. Civil servants are accountable to minister. Ministers are accountable to legislature and legislature are accountable to electorate. So the act contradicting the first link may violate the principle of parliamentary democracy, which is a part of the basic structure of doctrine. Violate collective responsibility. Department secretaries will bring certain matters directly to the LG and Chief Minister and Chief Secretary without consulting the concerned minister. Okay, as per the Article 239 AA, the LG has to be on the act on the aid and advice of the Council of Ministers, except when exercising functions at discretion. So provision of the Act explain the discretionary and the overriding power of LG, violates collective responsibility and triple chain accountability, violates triple chain accountability, power is given to the central government. Non-clarity of the controversy. The Act provides for bringing matters that may bring government of national capital authority in controversy with the central government to the notice of the LG. It but does not define these controversial matters. But does not define these the Act provides for bringing matters that may bring government in controversy with the central government to the notice of LG, but does not define these controversial matters. What are the controversial matters? Given the system of the Delhi administration has been in flux for a long time, development following ideas can be explored. Different. There are varying models of governance of capital cities in other countries which can be studied for developing a model for Delhi. Capital as a federal district. Abuja, Brasilia, they have varying degree of federal control over these cities. The city government also carries out state functions. Here the capital is of municipality under the state government. Full-fledged state, Mexico City. A 2-tier metropolitan authority can be created with elected municipal councils and regional government. In Australia, the Sydney metropolitan area divided into 31 local government, with the state government playing a coordinating role. The places with the central government officers and their affiliates can be placed under the central administration, while the rest of the NCT can be domain of the state. The places with central government officers and their affiliates can be placed in the central government, while the rest of the NCT can be domain of the state capital. Domain demarcation, decentralization of the decision making to municipal council and regional government, and the city metropolitan divided into 31 local government. Enforcement officer municipalities can be provided with enforcement powers through community police officers for civil compliance. No confidence. Recently, the Union government faced the no confidence motion in the monsoon session of the Parliament. No confidence motion. A legislative resolution introduced in the Lok Sabha that lost the opposition to challenge the government's majority and ability to govern. A majority ability to govern. In the parliamentary democracy, government can be in power only if it commands a majority in the directly elected house, implying that if a no confidence motion is passed, the government of the day will have to resign. The motion of no confidence can only be moved in the Lok Sabha, by any of its MPs. Constitutional article, rule of business in Lok Sabha. Article 75 of our constitution embodies this rule by specifying that council of ministers are collectively responsible to the Lok Sabha. A rule Article 75(3), Rule 198 of the Rule of Procedure and the Conduct of Business in Lok Sabha provides a provision regarding the motion of no confidence in the Council of Ministers. Motion of no confidence need not set out any ground on which it is based, even when grounds are mentioned in the notice. कोई ground नहीं है. Even when grounds are mentioned in the notice and read out in the House, they do not form a part of the no confidence. A part of the no confidence motion. Okay, speeches. Unless leave is granted by the House to move the motion, no speech is permitted in support of the motion at the time of obtaining the leave of the House. After a no confidence motion has been discussed and negated by the House, another no confidence motion cannot be moved in the same session. Usual process for a no confidence motion: House expresses its want of confidence in the Council of Ministers. Speaker examines if the no confidence motion is in order. The member who has tabled the notice asks for the member who has tabled the notice ask for the leave of the House to move the member who has tabled the notice ask for the leave of the House to move the motion. So Speaker then calls upon members who are in favor of leave being granted. If not less than 50 members arise, the separate declare. If not less than 50 members rise, the Speaker declares that leave is granted by the House. The motion is then taken up for discussion within 10 days from the date of the grant of the leave. Implication of the no confidence motion: political vacuum. The passing of the no confidence motion leads to the resignation of the Council of Ministers, which may lead to the political vacuum. The sudden removal of the political executive may lead to the administrative confusion and political uncertainty. Politically motivated no confidence motion tend to affect the optimal time utilization in Parliament. For instance, up till the current motion, total of 456 hours have been spent discussing a no confidence motion. 456. If no other party is able to prove the majority, then the citizens have to bear the expense of conducting the general election. The first no confidence motion was discussed in the third Lok Sabha. Since then, a total of 26 no confidence motions have been discussed in Parliament. पहला थर्ड तीसरे में हुआ था, अभी तक 26 हो चुके हैं. 25 of them were negative and one motion led to the resignation of the government in 1979. This record highlights the privilege of opportunity to challenge the government and at the same time the stability of the India's democratic system. Mediation Bill 2023. Both the House of the Parliament recently passed the Mediation Bill 2023, seeking to promote the mediation as a preferred mode of alternative dispute resolution in India. Mediation Bill 2023 defines mediation. It includes the expression mediation, expression mediation, pre-litigation mediation, online mediation, community mediation, conciliation, or an expression of similar import. Here, the parties attempt to reach an amicable settlement of their dispute with the assistance of a third person referred to as mediator. Voluntary pre-litigation mediation. The parties can attempt to settle a civil dispute or any commercial dispute by mediation before approaching any court or certain tribunal. Center may amend this list. List includes relating to claims against the minors of the person, claims against dispute not fit for mediation, relating to claims against any minor or person of unsound mind, involving criminal prosecution affecting the right of the third party. Territorial jurisdiction. Mediation to take place within the territorial jurisdiction of the court of the tribunal or competent jurisdiction unless parties agree otherwise or undertake mediation in online mode. Mediation to take place within the territorial jurisdiction of the court or tribunal of competent jurisdiction unless parties agree otherwise or undertake mediation in online mode. Mediation to take place within the territorial jurisdiction of the court of tribunal. Mediation to take place within territorial jurisdiction of the court or tribunal of competent. Mediation to take place within the territorial jurisdiction of the court or tribunal of competent jurisdiction unless the parties agree otherwise or undertake a mediation in an online mode. Timeline for conducting the mediation must be completed within 120 days, which may be mediation 120 days, which may be extended for another 60 days with the consent of the parties. A party may withdraw from mediation after 2 sessions. A court and next mediation must be conducted as per the rules framed by the Supreme Court or High Court. 2 सेशन के बाद कर सकते हैं 120 दिन इतना. Establishment of Mediation Council of India to promote mediation and develop India as a robust center for domestic mediation and international mediation, to make regulation for the registration of mediators. Mediation Council of India: 1 chairperson, 2 full-time member with experience in mediation or alternate dispute resolution, 1 part-time member including law, security and expenditure security, and 3 ex officio member. 1 chairperson, 2 full-time, 1 part-time, and 3 ex officio. As a body or organization recognized by the Mediation Council of India for conducting mediation, mediation can be done by the authority constituted under the Legal Service Authority Act 1987. To resolve the dispute likely to affect the peace and the harmony among the residents of the locality by a person of 3 mediator. Agreement resulting from mediation will be binding and enforceable in the same manner as court judgment. Agreement resulting from mediation will be binding and enforceable in the same manner as court judgment. Agreements resulting from mediation will be binding and enforceable. Verdicts can be challenged before a competent court within 90 days. Binding होगा, enforceable होगा. Challenge करना है तो 90 दिन. within 90 days mediated settlement can be challenged on ground of the fraud corruption कि भाई हमारे साथ fraud हुआ है, कुछ corruption है, impersonation, dispute not fit for mediation only. About alternative dispute resolution, ADR refer to different ways people can resolve dispute without a trial. Other than the mediation, ADR mechanism include arbitration procedure in which a dispute is submitted by agreement of the parties to one or more arbitrators who make a binding decision on the dispute, conciliation or non-binding procedure in which an impartial third party, the conciliator, assists the parties to a dispute in reaching a mutually satisfactory agreed settlement in the dispute. Negotiation. It is also non-binding procedure in which a discussion between the parties are initiated with the intervention of any third party with the object of arriving as a negotiated settlement. Negotiate, conciliate, arbitration and conciliation Act 1996, Arbitration and Conciliation Act Amendment 2019 after the establishment of Arbitration Council of India 1969, 1996 फिर 2019 Arbitration Council of India, Legal Service Authorities Act 1987, New Delhi International Arbitration Center Act 2000 for the establishment of New Delhi International Arbitration Center for facilitating the constitutional arbitration. Commercial Code Act 2015 provides for such commercial code for adjudicating commercial dispute. Need for a mediation bill. Dedicated guide. Presently, there is no comprehensive law governing the various aspects of mediation procedure. Reduces the burden of court. 5.02 crore cases were pending in various courts. 5.02 crore. It helps to preserve the relationship among the disputants and that reduces the chance of any future dispute. This is also in line with India's commitment as a signatory to the United Nations Convention on International Agreement resulting from mediation. Fulfilling Singapore Convention commitment. In line with India's commitment as a signatory to the United Nations Convention on International Settlement Agreement resulting from mediation. International Settlement Agreement resulting from mediation. The bill introduces the concept of online mediation, which can reduce the travel cost of the litigant. People resolve the dispute in a short period as compared to court. Only 55% of India have access to internet, and only 27% complete compatible devices. As per the Niti Aayog, Mediation Council requires prior approval from the central government before issuing regulation relating to the essential function. Mediation Council requires prior approval from the central government before issuing any regulation related to the essential function. This raises the conflict of interest as the government is the biggest litigant in the country. सबसे बड़ा litigant कौन सा है? Government. तो conflict of interest हो जाएगा. ओके, ज़्यादा नहीं है, हो जाएगा. Okay. And for the issue of international mediation, it does not provide for the enforcement of settlement agreement resulting from the international mediation conducted outside India. No punishment liability for breaching confidentiality. No punishment liability for breaching confidentiality. No punishment or liability for breaching confidentiality. Issue of international mediation. No punishment liability for breaching confidentiality. It includes government-related dispute. Standing committee had recommended that government-related no punishment liability for breaching confidentiality. Issue of international mediation. Include government-related dispute. Standing committee had recommended that government-related dispute be included in the bill with the start of the mediation to ring-fence any potential breach of confidentiality to have a formal agreement. Also, there is a need for the provision for punishment liability for breaching the confidentiality. The number of disputes in the schedule should be reduced to ensure that the maximum number of disputes go through pre-litigation mediation guidelines for the celebrities, influencers, and the virtual influencer. Advertising Central Council of India has released the comprehensive guideline for influencer advertising in digital media. About Advertising Central Council of India, headquartered Mumbai, established in 1985 as a non-profit company under Company Act 2003. It is a voluntary self-regulatory organization comprising members from marketing, creative, media and allied companies in India, protecting Indian consumer interests through self-regulation in advertising. These guidelines are an extension to the guideline for the prevention of misleading advertisement and endorsement. These guidelines are an extension to the guideline for the prevention of misleading advertisement and endorsement. Advertisement and endorsement for misleading advertisement 2005. Department of Consumer Affairs Ministry will actively monitor and enforce these guidelines. Department of Consumer Affairs Ministry will actively monitor and enforce these guidelines are an extension to the guideline for prevention of misleading advertisement and endorsement for misleading advertisement. Department of Consumer Affairs Ministry will actively monitor and enforce these guidelines. Influencer found to be in violation of the new guidelines could be face penalties under the Consumer Protection Act 2019. यार Okay, guidelines for the prevention of misleading advertisement and endorsement for misleading advertisement 2005. Key provision of the guideline. It prohibits surrogate advertisement. No surrogate advertisement like alcohol ban advertising for soda, music, Alcohol ban. Advertising for sodas, music shall be made for goods or service for advertising is prohibited or restricted. Prohibit targeting children. Advertisements that take advantage of children's inexperiences have been prohibited. 8 penalties. Violation may lead to the penalties under the Consumer Protection Act 2019 and other relevant provision. CCPA can impose a penalty. Consumer CCPA can penalty up to ₹10 lakh on manufacturing, advertisers and endorsers. For subsequent offences, the penalty goes up to ₹50 lakh. Guidelines for all. Disclose all material connections such as monetary or other compensation-free product between the advertiser and the influencer. It must be upfront and prominent so that it is not missing by an average consumer. Terms including advertisement, sponsor, collaboration, paid promotion can be used, which must be indicated as a hashtag or headline tag. Due diligence. Endorsers are encouraged to conduct a thorough review and ensure that they are in position to substantiate their claims made in the advertisement. They must use or experience a product or a service before endorsement. Influencers must refrain from making false, misleading or exaggerated claim for health disclosure. इसके बाद एक और टॉपिक है. Okay, for health disclosure. Disclose certificate. Endorsers must disclose that they are certified health fitness expert and medical practitioner. Endorsers must ensure that the audience understand that the advices should not be seen as a substitute for professional medical advice. Registration can offer investment related advice. Is result like banking, financial service, insurance only after registering with SEBI. Other financial influencers must also possess appropriate credentials such as license from the insurance regulator. Challenges implementing the guideline. Rising number of influencers and social media platforms has made regulation difficult. Less awareness among the people and also influencer about the guideline, improper disclosure and the disclaimer. Need of the guideline. It affects the decision making of the consumer. People believe in the celebrity influencers and the virtual influencers. They tend to follow whatever they say or endorse. This may lead to negative consequences as financial loss, health issues. It may violate the right to choose, right to information, and right to be safeguarded against the harmful products and the service. The social influencer market is expanding quickly. The social market influencer. The social influencer market is expanding quickly. New projected to be worth around ₹2,800 crore by 2025. Increased use of social media for professional activities and influencer violation, comprising almost 30% of the advertisement taken up by the Advertising Standards Council of India. Increased use of social media for promotional activities. Increased use of social media for promotional activities and influencer violence. Increased use of social media for promotional activities. Okay. An influencer violation. People have ample information about the celebrities, for instance, like any cricketer, but consumers may not necessarily know much about influencer. Guidelines will help celebrities and the influencer to understand their social responsibility and will make them more sensitive towards their followers. Posting an advertisement without mentioning that it is an advertisement. Also, they claim themselves as expert in the spheres of the BSY health and nutrition protection service, but they really may be difficult. Reality may be different. Conclusion. Guidelines will help protect the interest of the consumer. It will bring transparency to advertisement by checking misleading advertisement. It will help consumers identify the promotional content and make informed decisions on the product or service. Guidelines will help protect the interest of the consumer. It will bring transparency to advertisement by checking misleading advertisement. It will help consumer identify promotional content and make informed decisions on product or services. Registration of Birth and Death Amendment Act 2003. Recently, the Act to amend the Registration of Birth and Death Act 1969 was Registrar General and the Census Commissioner. Registrar General and the Census Commissioner of India, New Delhi, founded in 1961, Ministry of Home Affairs. Registrar General, New Delhi, Home Affairs, 1961, conducted the population census and monitoring of the implementation of registration of birth and death. The Census Commissioner India is also in the Census Commissioner in India. India is also registered as the Registrar General India under the RBD Act 1969. Key feature of the Registration of Birth and Death Act 1969 provides the regulation and the registration of birth and death in India, provide for the appointment of the Registrar General of India by the central government for the implementation of this act, chief registrar, district registrar, and registrar to be appointed in every state by the state government for the implementation of the act in the state, district, and local area respectively. Registrar certain provision person to report birth and death to the registrar like a medical officer in charge, provide to obtain an extract from the registrar related to any birth or death. In respect of the birth or death occurring in a house, it is the duty of the head of the house, and in a hospital, the medical officer in charge is responsible for reporting a birth certificate can be obtained without the name of the child. The registration of the birth and death fall under the concurrent list. As of 2019, as the national level of registration of birth was 90% and death registration was 92%, the Act has not been amended since its inception. Therefore, new amendments are brought to keep pace with the societal change and society में change हो रहा है, technological advancement, and to make citizen to move and make Act more citizen friendly. upon efficient and a transparent delivery of public service and social benefit. Key features of the birth index 2008. And database of the birth index. It adds to that the Registrar General of India will maintain a national database of the registered birth index. Chief Registrar and the Registrar will be obligated to share data of the registered birth and date to the national database. Chief Registrar shall maintain the similar database at the state level, provide digital registration and electronic delivery of the digital registration and the electronic delivery of certificates of birth and death, to collect the Aadhaar number of the parent and the informant in case of birth registration. It states that the national database may be made available to other authorities preparing or maintaining their database like population registry or electoral roll, ration card. The information will be used for purposes including admission to an educational institution, preparation of voter list, appointment to a government post. Purpose including admission to educational institution, voter list, appointment. Any person aggrieved by any action or order of the registrar or the district registrar may appeal to the district registrar or chief registrar respectively within 30 days. So it is against the fundamental right. Denying the admission to school without the birth certificate may violate the fundamental right to education under Article 21A. Linkage across the database does not require consent from the person whose data is being linked, which is against the right to privacy. Sole conclusive proof of it. The Act does not provide alternative proof if a person does not have a birth certificate. Provide sole conducive proof of age. Centralizing the database may lead to mass surveillance. Centralizing the database may lead to mass surveillance. The Act in its implementation will help with e-governance. Although the Act defines a database, organized collection of data generally stored and accessed in electronic form from a computer network, the government could bring robust privacy and the surveillance laws. Press and registration of the periodical bill. Bill introduced in Rajya Sabha seeks to replace the press and registration of the books Act 1987, which governs the registration of the print and publishing industry in the country. The central government may appoint a Press Registrar General of India and empowers Press Registrar General of PGI, Press General of India, to suspend or cancel certificate of registration. District person convicted of offence involving terrorist or unlawful activity to bring out any periodical. Decriminalization of various offences. Decriminalization of various offences as mentioned under the Press Regulation Board Act 1860. Improper declaration of offences provides for the Appellate Board, Press and Registration Appellate Board, headed by the Chairman, Press Council of India, to hear an appeal against the refusal of grant of registration, imposition of penalty or suspension of registration. Books taken out of the purview of the PRB bill, which were earlier subject to it. Significant. Simplifies registration process of periodical and bring transparency in governance of press and periodical. It simplifies the registration process of periodical, bring transparency in governance of press and periodical. It simplifies the registration process of periodical. Simplify the registration process of periodical, bring transparency. Simplify the registration process of periodical, bring transparency in governance of press and periodical. It simplifies the registration process of periodical, bring transparency in governance. Simplify registration process of periodical, bring transparency, uphold media freedom, improve ease of doing business, particularly for small and medium enterprises. About Press Regulation Board Act 1867, enacted during the viceroyalty of Lord John Lawrence. 1860 had helped government control the press, regulate book publishing, and eventually curb the freedom of speech and expression. Advocate amendment bill. The bill passed by the Rajya Sabha seeks to make the act of tout punishable and repeal certain provisions of the Legal Practitioner Act of 1871 which have become obsolete. Bill provides that every High Court and a district judge can frame and publish list of tout. Sare High Court or District Court can frame and publish list of tout. Such person named in the list of touts will be excluded from entering the court premise. Tout refers to a person who either proposes to procure or procures the employment of a legal practitioner in return of any payment. Okay, thank you so much.